And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The flashing lights hit your rearview mirror. Your heart rate jumps, but you know your documents are ready. As the officer approaches your window, they ask a question that is designed to trip you up, a question that most legally armed citizens answer incorrectly, resulting in immediate escalation. The question is simple. Do you have any weapons in the vehicle? Well, your reply could be the difference between a minor ticket and a major felony charge that destroys your gun rights forever. Most people try to be polite. They try to prove they are the good guy, and in doing so, they provide the exact evidence prosecutors need to charge them. The solution is not dishonesty, and it is not aggression. It is 5 specific words, uttered calmly, which legally terminate the conversation and protect your rights. I'm going to give you those 5 words in just a minute. But first, you must understand why you cannot afford to volunteer information in that moment. When you're stopped, your instinct is cooperation. If you're carrying legally, you think it's saying, yes, I have a permit, the gun is in the console, it's not loaded, sounds reasonable. Here's the danger. You just volunteered several different statements, and every single one is a legal landmine. Maybe you state the gun is unloaded, but your state law defines loaded as having a magazine in the well, even if there is no round in the chamber. Now you've made a contradictory statement that can be used to suggest deception. Maybe your concealed carry permit expired last month and you forgot to renew it. You just confessed to illegal carry. Maybe you describe the location of the weapon, giving the officer justification to immediately order you out of the car, which escalates the entire interaction. Defense attorneys often lose their minds when they hear what clients said during routine traffic stops. Why? Because the Fifth Amendment right against self-incrimination does not disappear just because you have a valid permit. You're not obligated to assist law enforcement in building a potential case against you. To understand the strategy, we must look at the legal framework. This all ties back to the 1968 Supreme Court case, Terry v. Ohio. This case dictates that an officer can perform a pat-down or Terry frisk if they have reasonable suspicion you are armed and dangerous. Notice those 2 conditions. If you have a legal firearm, you are armed. That is the simple fact. But once you volunteer that information, you have just provided 50% of the legal justification for escalation. Now, the officer only has to interpret your movements, your tone, or your perceived nervousness to satisfy the dangerous part. If you do not volunteer that you are armed, the officer needs an independent reason to suspect danger before they can proceed with a search or removal. We need a statement that confirms nothing, denies nothing, and invokes your constitutional protections without sounding aggressive. If this insight alone is new to you, hit the subscribe button right now. The Law Advisor channel is dedicated to giving you the legal defense strategies you need before you're standing on the side of the road facing potential charges. So, when the officer asks, "Do you have any weapons?" Here are the 5 exact words you use. I don't answer questions. That's it. 5 words. Simple, direct, legal. You're not being rude. You're not saying, "I plead the 5th," in a dramatic or antagonistic way. You're calmly exercising a recognized constitutional right. The Supreme Court has repeatedly affirmed your right to remain silent and decline to answer questions during a police encounter. Critically, you are not lying. Lying about having a firearm is a crime in many jurisdictions. If you say no and you're carrying, you risk felony charges. By saying, "I don't answer questions," you have declined to provide information, which is entirely your right. You have drawn a clear legal boundary that protects you from self-incrimination. Now, let's discuss the immediate aftermath, because this is where panic sets in. The officer might try to pressure you. They might say, "Sir, I'm just trying to make sure everyone is safe." You respond by keeping your hands visible, 10 and 2 on the steering wheel, calm and respectful. You can say, "I understand. Officer, I still don't answer questions." They might try a psychological tactic. "Are you refusing to cooperate?" This is designed to make you feel guilty, but exercising your Fifth Amendment rights is not a refusal to cooperate. Your response should be, "I'm cooperating fully, officer. I'm just not answering questions." You comply with lawful orders, like providing your license and registration, but you volunteer 0 conversational details about where you're going, where you have been, or what you might be carrying. Let me give you a real-world example of why this tactical silence works. A CCW holder in Pennsylvania, a state that does not have a duty to inform law, was stopped for speeding. The officer asked about weapons. The driver volunteered, "Yes, I have a pistol in my waistband." The officer immediately became agitated, ordered him out of the car, and during the removal of the firearm, claimed the driver made a furtive movement. The situation escalated massively. The man ended up on the pavement, his car searched, and although nothing illegal was found, He incurred thousands of dollars in attorney fees because he volunteered information he never legally had to give. Those 5 simple words could have prevented that entire traumatic encounter. Now we have to talk about the crucial exception, duty to inform states. In about 10 states, including Ohio, Texas, and Michigan, you are legally required to notify the officer immediately that you are carrying. If you are in one of these states, you must comply. But even here, the strategy is minimum words, maximum rights. You inform the officer of the minimum required by law, and then you stop talking. The law typically requires you to state that you possess a permit and that you are currently armed. It does not require you to answer follow-up questions about the gun's location, whether it is loaded, or why you're carrying. In a duty to inform state, the interaction looks like this. When the officer approaches, you hand over your license, registration, and CCW permit together. You calmly state, "Officer, I am required to inform you that I have a valid concealed carry permit and I am currently armed." Then you stop. Hands visible, you wait for instructions. If the officer then asks, "Where's the gun?" you say, "I'd prefer not to answer questions, but I will follow your instructions for everyone's safety." This is compliant, but silent. You acknowledge their safety concern, but you did not give them the exact location, which would only lead to more questions like, "Is there a round in the chamber?" or "Do you have other weapons?" Each additional question is a trap. I see gun owners making this mistake constantly. They think the goal of the traffic stop is to make the officer trust them or like them, so they start over-explaining their philosophy on self-defense. They try to justify why they have a fully loaded firearm. That discussion only helps the officer build a narrative that suggests you are overly aggressive or paranoid, which fulfills the dangerous criteria. Your goal is simply to get through the stop safely and legally, period. You can't talk your way out of an arrest, but you can absolutely talk your way into one. What if the officer decides to search your vehicle? This is a separate, critical legal issue governed by the Fourth Amendment. An officer needs your consent, probable cause, or a warrant to search your car. If they ask, "Can I search your vehicle?" you immediately, calmly, and clearly state, "I do not consent to searches." If they search anyway, you do not physically resist. You simply reiterate, "I do not consent to this search," and you comply with all physical orders. By explicitly denying consent, you preserve your Fourth Amendment rights, making it possible for your attorney to challenge the search later in court and potentially suppress any evidence found. If you had consented, that option is gone. Every word you volunteer, every detail you offer, can be used by a prosecutor and twisted against you. You might think you're stating a simple fact, the gun is loaded. But what if that specific type of firearm carriage is prohibited during transit in that particular municipality without a specific exemption you weren't aware of? You just confessed to violating a complex transportation statute. By remaining silent, you force the state to prove every element of their case without your self-incriminating help. The final piece of advice is regarding tone and body language. When you say, "I don't answer questions," your tone must be calm, neutral, and respectful. You are politely declining to speak, not challenging authority. Your hands stay visible, either on the wheel or the dashboard. If you need to reach for registration, you announce it clearly. "My documents are in the glove box. I'm going to reach for them now with my right hand." This clear communication shows respect for officer safety while you maintain your constitutional ground. Remember this fundamental truth. You are a law-abiding citizen. You have the right to carry, and you have the right to remain silent. These two rights are not in conflict. When the officer asks about weapons, you know the 5 words. When they ask follow-up questions, you know the 5 words. And when the stop concludes, you immediately contact your attorney to document the entire incident before you talk to anyone else about what occurred. These strategies are your shield. They force the officer to rely on probable cause and observation, not on your helpful but legally dangerous conversation. Minimum words, maximum rights. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget. Knowledge is the ultimate defense. I will see you in the next one.